Good morning, everyone. Thanks for joining us in this session. We're going to talk about some famous lawyers today, none of whom want to be famous anymore because they became famous for the wrong reasons. But before we do that, I do want to give a shout out to the real hero of the day, who is Graham Carney, sitting next to me. Graham is an amazing associate in our litigation group here in Dallas. And he agreed to fill in at the last minute when one of our colleagues came down with the flu yesterday. His primary focus, aside from litigation lately, has been helping us with this presentation. So hopefully you'll really enjoy the materials that we've pulled together for you today. And with that, I'm going to kick us off first with a recent bankruptcy story that you might have seen in the news. The first misstep that we're going to cover comes out of the Neiman Marcus bankruptcy in 2020. Dan Kamensky had earned 2 degrees from Georgetown, worked as a big law bankruptcy lawyer, and did stints at both Lehman and Paulson before he founded his own investment firm, Marble Ridge Capital, which you might have heard of. His resume is proof that not all the lawyers that we talk about today are at all stupid. In fact, it's quite the opposite. Many of us would have been proud to work with Dan as a client or co-investor before all this happened. What brought Dan down was when Marble Ridge sought and obtained a seat on the Unsecured Creditors Committee in the bankruptcy. Kamensky, as Marble Ridge's representative on the committee, pressured Jeffries, who was another bidder for assets, to refrain from making a higher bid on those assets that were at issue in the bankruptcy. This is a major problem because everybody that sits on a creditors committee acts as a fiduciary for all unsecured creditors in the case. So in that capacity, you're trying to get the highest and best bid for these assets. Instead, what happened here, Kamensky's goal was to make sure that Marble Ridge could get the assets at the lower price. And Jeffries had every right to bid on those assets, and the assets should go to the highest bidder. He even threatened to stop sending Marble Ridge's business to Jeffries if they didn't move forward with their bid. So initially they did take down their bid, but they were honest with the committee about why they had done so, and they told the truth. And that was what brought Kamensky down, because the committee's professionals and other members knew that what he did was improper. He actually even tried to run away from calls that he had made, but those calls and chats were actually recorded by Bloomberg Chat and some of the Jeffries employees. And on some of those chats, he had acknowledged that if his actions came to light, that he would go to jail. But unfortunately for him, Jeffries had no interest in covering for him. And in fact, they later indicated interest in bidding on those assets, and that sale was resolved by settlement. So at the end of the day, he wound up arrested, pled guilty to bankruptcy fraud, had to watch Marble Ridge be wound down, and he was sentenced to 6 months in prison. He's now on supervised release with 2 months to go, and his law license was suspended. So pretty severe consequences here. This brings to mind a couple relevant statutes and rules. One, the bankruptcy fraud statute, which is 18 USC 152. And I think we're going to be circulating these materials later, but essentially a person who knowingly and fraudulently gives, offers, receives, or attempts to obtain any money or property, compensation, reward, advantage, or promise for acting or forbearing to act in any case under Title 11 shall be fined under this title, imprisoned not more than 5 years or both. So I mean, this is a pretty serious violation here. And then also Rule 8.04, which is that a lawyer shall not commit a serious crime or commit any other criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, or engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And we're going to see that in a couple of these studies. With that, I'll turn things over to Graham for our next one.
Like Becky said, I'm Graham. Happy to be here filling in for Jordan. He's a great guy. I hope you get to meet him, but he works in our attorney malpractice group. So hopefully, be careful what you wish for. I'm going to talk about Jeffrey Workin. He started his career as a big law associate, ended up working in the prosecutor's office for the DOJ, prosecuting fraud claims. He did over 20 corporate fraud investigations, and then decided to leave to become a partner at a big DC firm. Before he left, had a brilliant idea to steal a couple of sealed whistleblower complaints to try to garner business at his new firm. That plan ultimately unraveled because he started contacting people to try to sell those complaints, to then to sell the complaints so that people knew what was coming down the pike. He flew from New York to California, tried to sell the complaint to the in-house counsel for one of the companies that was a defendant for $300,000. He showed up in a wig and a fake mustache. And the person he had contacted had immediately got in touch with the FBI. So the FBI was there waiting for him. Yeah. So I don't think those are real pictures of him, but hopefully he did a little bit better, but who knows? He pled guilty to obstruction of justice and interstate transportation of stolen property. He was disbarred under Maryland Rule 8.4B, C, and D. The Texas rules are similar to what Becky mentioned. Lawyers shall not commit a serious crime. It's also worth considering, and this will come up in some of the later ones as well. A lawyer shall hold funds and other property belonging in whole or in part to clients or third persons that are in a lawyer's possession in connection with a representation separate from the lawyer's own property. Other client property shall be identified as such, appropriately safeguarded. Hold on, sorry, I skipped ahead. So he got 2.5 years in prison, not a life sentence, and DOJ prosecutor to big law partner. The next transition on that career path isn't usually e-discovery vendor, but that's where he is at now. It seems like he's opened up his own shop, and he says on his website, I have learned more from my mistakes than from my successes. I believe in second chances and that nobody is defined by the worst thing they have done, which potentially could be the fake mustache.
So now we're going to move on to a very famous lawyer with an even more famous wife. So be taking a gander at this woman and see if you recognize her. There might be some fans here. But this is the story that all of us learn in Ethics 101 of being a lawyer, which is thou shalt not steal from thy clients. This gentleman, his name is Tom Girardi, and he was a legendary LA plaintiff's lawyer. And he was really famous because it was his settlement that led to the Aaron Brockovich movie, or inspired the Aaron Brockovich movie. So that's how he rose to fame. And he built his law firm, which was called Girardi Keese, into a very successful and well-known firm. And even though they won some settlements, they did eventually go insolvent. And following insolvency, a judge in the Northern District of Illinois entered a civil contempt charge against Girardi and his firm, and a judgment in the amount of $2 million plus interest, and this was in December 2020, and referred the case to prosecutors. So you may ask, where did the money go? Next slide, please. Well, apparently he spent it on his wife, who was a real housewife of Beverly Hills at the time. One of the alleged uses of the funds was a pair of $750,000 earrings. I'm sure they were beautiful. Unfortunately, it was alleged to be with client money. One trust beneficiary claims that Girardi owes more than $101 million to his former clients. He pled guilty to violating 18 USC 152.6, which is bankruptcy, bribery, and extortion. But even now, they're trying to get the money back and still actively fighting in court to get what they're owed.
So this next one kind of seems like another obvious wrong, but nonetheless, it happened. You might remember this story from a couple of years ago when many of us were locked down with COVID. During the protests of summer 2020, 2 New York lawyers decided to throw a Molotov cocktail into a police car. They were arrested. They were charged with 7 felonies, and then they both pled guilty to one of the 7 counts brought against them back in October. They've been under home detention for the last 2 years, and they're scheduled to face sentencing on May 25th and May 31st, respectively. And then some of you might have seen this pop up in the news just recently, because one of the outstanding questions people are talking about is if they will push for a terrorism enforcement to their sentence, which would result in an additional 10 years in prison. One of them, who was a large associate, it was not a large associate, no offense, was an associate at a large firm, has been suspended without pay for nearly 2 years. And so we have a next slide that kind of sums this up, that if you have a problem, if you just throw one of these, boom, you'll have a completely different set of problems. And I think the moral of the story here, I mean, obviously we know this already is a problem with Rule 8.04, but it's just, I think, a reminder to be mindful as an attorney, but also generally as a human, of your conduct and behavior in all sorts of contexts, not just when we're at our desks.
So from here, we mark a transition from overtly violent and crimes and theft into the world of fraud and corruption. As you can see here, corruption, it's something some want less of and others want more opportunity to participate in. These next folks wanted more of an opportunity to participate in the corruption. As a capital markets lawyer, this story is very near and dear to my heart. This is what I go in front of boards and scare them as often as I can. But so, this gentleman, Gene Levoff, used to be a top corporate attorney at Apple. He was actually the one in charge of pre-clearing insider trading trading requests and enforcing the policy. So he has unfortunately been indicted for insider trading. He didn't pre-clear his own trades, made a profit. So he moved to have the indictment dismissed. The court denied. Judge has entered consecutive continuances due to the pandemic, and it's still been continued more recently. The SEC has come after him as well, charged civilly, although they're waiting to see the outcome of the criminal case. And so relevant statutes and rules here, other than the federal insider trading laws, let's talk about ethics laws. Texas Rule 105B4, a lawyer shall not knowingly use privileged information of a client for the advantage of the lawyer or of a third person unless the client consents after consultation. And then Texas Rule 804 that we've mentioned a few times, a lawyer shall not commit a serious crime, which would include insider trading on information you have about the company.
So as it turns out, our public servants aren't always free from corruption either. Pictured here is Ed Pawlowski. He's formerly the mayor of Allentown, Pennsylvania, and he was convicted for soliciting bribes from law firms and engineering companies in exchange for city contracts. He is only one of the colorful characters that's involved in this mess. The city's finance director, Garrett Strathern, got 6 months of home confinement for helping to rig a city contract. And this is what has earned this case the meatball case name. He tried to run from some recorded calls where the discussion was about picking up the meatballs, which of course he claimed was not the bribe money. And I guess we'll never really know what he was actually referring to by the meatballs, but it's interesting to note here that the prosecution did actually take the position that the meatballs did mean meatballs, and that the mayor's defense lawyer had tried to make Strathern seem like more of a bigger player in this scheme than he actually was. That brings us to the lawyer that was involved in this, the city's assistant solicitor, Dale Wiles. He got 1 day in jail and an automatic disbarment for steering a contract to a firm backed by the mayor's campaign donors. The prosecutor said that Wiles initially lied to FBI agents, failed to turn over documents in response to a subpoena. And even though his jail term was only 1 day, as you can see on the slide, he got very little sympathy from the prosecutor or the court at sentencing, as they said he was a lawyer and he should know better. So here, this again brings into play 8.04 that we've discussed a couple of times already, but also 1.02, a lawyer shall not assist or counsel a client to engage in conduct that the lawyer knows is criminal or fraudulent. And then 1.05C, which authorizes you to disclose confidential information when the lawyer has a reason to believe that it's necessary to do so in order to prevent the client from committing a crime or fraudulent act, or if necessary to rectify the consequences of a client's criminal act in the commission of which the lawyer's services had been used. I think we'll go back to Kat.
So this one's pretty self-explanatory just by looking at this guy's photo. Bless his heart. He's having a really bad day. So this is Gordon Kaplan. He was the co-chairman of a major New York law firm, well-respected, well-known, well-paid. He paid $75,000 to a college admissions consultant to rig his daughter's ACT score, and he got caught. He pled guilty to conspiracy to commit mail fraud and honest services mail fraud, but he got off pretty light, 2-year suspension from the bar and a 1-month prison sentence, some community service, and a $50,000 fine. And what's really interesting about this is the disciplinary decision was very kind to him. They said, it is difficult, if not impossible, to imagine Kaplan ever again deliberately crossing the line and acting criminally or unethically. And that's nice when you're the co-chairman of a major New York law firm, but it makes you wonder, would I get the same treatment from the disciplinary committee myself? We've hit these relevant statutes before, but Texas Rule 804, you should not commit a serious crime. There's also a New York rule, which generally provides for disbarment upon conviction of a serious crime. These days, Mr. Kaplan is starting over. He got a fresh start. His law license was reinstated. He's doing some consulting work. He is helping people re-entering society after prison. And the reason this has moved so fast was that they backdated his sentence, starting, or his law license was suspended, backdated to his sentence. So this moved pretty quickly for him, but he certainly doesn't want to go to jail again. Poor Mr. Kaplan.
So next we have Scott Wallace. I think probably a subject of an upcoming Netflix documentary, but he's not that easy on the eyes, so maybe not. So he, over several years, took on 6 different identities. He started under his own name, Scott Wallace. In New York as a litigator, he made partner at a big firm. He initially came into trouble because he was part of an overbilling scandal, was disbarred in New York, but never showed up to his disbarment proceeding, and that was just the beginning. Basically, for the next couple of years, he moved around the country, took on different aliases, did multiple different jobs during that time, and ended up in Florida, where he got married. And then, so he was part of these different scams, and then he actually was pretty successful. So he moved from Florida, he went back to Massachusetts and was a real estate broker and had some successful clients and made a good amount of money, and then eventually started on this new project with people he had worked at before, and then started taking all their investment money, using it on personal expenses. He eventually got caught because he tried to go back down to visit his ex-wife in Florida and cash in on a investment account that he still had, and that's what led to his demise. So he got 81 months in prison. He was ordered to pay more than 1.9 million in restitution. And the relevant statutes are Rule 104, forbidding all legal fees, and a legal fee or unconscionable fee, back to the overbilling. 1.08, providing rules for business transactions with clients. And then 804 that we've talked about, shouldn't commit a serious crime. The next one is Lynn Stewart. She was a defense attorney who represented a lot of controversial and famous defendants. She thought the American system needed lots of work and sympathized with all kinds of people who wanted to change the system, even through violence. So she really became a notable character when she represented Omar Abdul Rahman, the blind sheik from Egypt. And the system was pretty lenient. She did get disbarred. She was only sentenced to 28 months in prison after being convicted of conspiracy and providing material support to terrorists by passing messages from the blind sheik to his followers in a terrorist organization. The messages she smuggled encouraged the sheik's followers to commit violence in Egypt. After being sentenced the first time, Stewart was allowed to remain free on bail pending appeal. She was resentenced 4 years later and served she started to serve her sentence in Fort Worth in 2009. She obtained compassionate release due to a cancer diagnosis and passed away recently. Relevant statutes in New York generally providing for disbarment upon conviction of a serious crime. And as we've said, Texas Rule 8.04, don't commit a serious crime.
So here we hit another transition point. We've been talking about things where you probably could never imagine yourself being in the same position, right? Are you going to pass messages to a terrorist organization? No. Do you see yourself realistically throwing a Molotov cocktail? Probably not. We're starting to move now into the realm of what could be considered a mistake. And this is where things get scary for practitioners, and where you have to start thinking to yourself, okay, if I started seeing this path happen, how would I react and what would I do and how can I change my practice? And this example is particularly relevant for folks working in-house. And this is the story of Rosenfield, who was an in-house attorney, and he gave himself a small equity share of a timeshare businesses that he organized for the owner of the company. And he didn't hide this from the owner. This was known by both of them, right, and built into the contract. However, he didn't advise his client, the owner, that he should get separate counsel, and he didn't give him time to go look for separate counsel when he was drafting these contracts. When it all came to light, Rosenfeld's interest in the entities was rescinded, and in New Jersey, which is where he practiced, the Supreme Court ruled that his salaries could be disgorged upon appropriate factual showing. They later settled, but that would have been considered as a penalty. And they found that he had violated New Jersey Rule 1.8, and they brushed aside any argument that the rule didn't apply to him because he was an in-house lawyer, so that didn't save him. Now, for any of you who work for public companies, I do want to draw this distinction. If you participate in a generally available equity plan that separate counsel has reviewed, do not fear. There's generally a distinction, at least for subordinate lawyers there, but all in-house counsel should be wary of these rules when dealing with an equity award.
All right, this next one falls into the same category that Kat was talking about a minute ago, that now we're kind of in that zone of things that we can see actually happening to ourselves that are more of sort of an honest mistake or a misstep. And this particular slide is a good reminder about in-house document preservation. In this case, the court found that SanDisk was negligent in preserving the emails of 2 former employees and the data on their laptops. The court was particularly unsympathetic to the company here because of its size and its technological expertise. So essentially, once the information was not available, the defendant was determined to have a culpable state of mind and about the failure to preserve, and they were sanctioned $150,000. We've also seen cases where your failure to preserve evidence can result in an adverse finding against you or your client. So this is very important. But the court's complaint here was about the in-house lawyers really boiled down to a lack of supervision of the document preservation efforts. And so this kind of issue, which from all appearances appears to be an innocent one or maybe negligent at best, can be avoided by using third-party document collection services when appropriate, even though we all kind of hate making that call and incurring that additional expense. But even when third-party services aren't justified, in-house counsel or others can protect themselves against what happened in this case by making a clear record, right, of the preservation steps, the process, and what that they have in fact supervised the document collection and preservation efforts. So just a little bit more care could have gone a long way.
Speaking of more care, this is the story that puts fear in the hearts of every big law partner. So this is the story of the General Motors UCC filing. It is the story of an honest mistake, and it's the story of insufficient supervision. And while it's the story of something that happened within a big law firm, it's equally applicable to large in-house teams where maybe you're working through layers of folks trying to get a big transaction done. So much of the work big law firms do is complex. The teams get big, but ethical issues and mistakes arise when things don't get delegated properly, or they don't get supervised properly once they're delegated. And it also happens when people take comfort in the size of the team and you assume that other folks on the team are covering, whatever it is that you are not looking at. And you don't stop to check the work that's performed by others, particularly as a lawyer, checking the work of non-lawyers. So one mistake came to light in the GM bankruptcy, and it's a little confusing. So I'm going to talk about GM and the lenders, right? Okay, so those are our two sides. So GM had paid off a loan, had its law firm prepare the documents, and they were going to release the lender's UCC loans. This is a fairly small loan compared to the size of the bankruptcy. The partner on Team GM's outside legal team asked an associate to prepare the UCC release, and the associate then had a paralegal do the lien searches. But when it came time to actually file the UCC release, the borrower's firm, so GM's firm, filed a termination statement which released not only the smaller loan, but also some of the liens related to a more recent $1.5 billion loan that had not yet been paid off. Neither borrower's counsel, so GM's law firm, nor lender's counsel caught the mistake. So it just went forward. When it came to light later in the bankruptcy, the Second Circuit upheld the termination of the lien. They actually went against the bankruptcy court, who had entered an order that would have treated that release as unauthorized and therefore ineffective. So $1.5 billion in play at this point due to a mistake. It resulted in a lot of complex litigation. Notably, some of the lenders sued GM's counsel directly, but the Seventh Circuit held that borrower's counsel, GM's counsel, didn't represent and wasn't liable to the lenders. So it's a problem not only checking the work that's done underneath you, but checking the work of other firms as well across the table. There are a lot of relevant statutes that kick in here. One is Texas Rule 101B. A lawyer shall not neglect a legal matter entrusted to the lawyer. Texas Rule 101, and there's the comment 6. And this one is a little scary sometimes for many of us. A lawyer's workload should be controlled so that each matter can be handled with diligence and competence. Texas Rule 503A, requiring a lawyer with direct supervisory authority over a non-lawyer to make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. So this is our supervisory obligation, and that would apply to any non-lawyers working with us.
So this next category is kind of even more scary and more situations that you could potentially see yourself in. And a lot of them have to do with this question of when you establish an attorney-client relationship, trying to nail down exactly who the client is, who the attorney is, and where the parameters of representation kind of start and end. So the first case we are talking about is Douglas Irish, who was an attorney representing Motorola in a dispute, and a former employee named Corley was sitting for a deposition, and the transcript goes, "Let me just ask for the record, are you represented by counsel today?" "Yes." "Is that Mr. Irish and his firm?" "Yes." And Mr. Irish did not correct him. Adversity later came to light between the former employee and Motorola, where they were adverse to each other, and Douglas Irish was going to be the attorney taking the deposition of Mr. Corley, and Mr. Corley's team moved to disqualify him because he had previously been represented as his counsel. The court didn't categorically deny or reject. They denied his motion, but they still said that Irish could not take Corley's deposition. So a couple of things in play here. Rule 112, governing representing an organization as client, which says that the lawyer for an organization represents the entity. Specifically 112E, in dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when it is apparent that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing, or when explanation appears reasonably necessary to avoid misunderstanding on their part.
All right, this next one in this case study, the accidental joint defense lawyer, we have two lawyers who changed firms, which we've all seen happen. They obtained conflicts waivers from their client, who was one defendant in a matter that they had relating to their change in firms. But then the lawyer's new firm, a major law firm, wanted to represent the plaintiffs in that same lawsuit. Other defendants in the lawsuit objected, arguing that a joint defense agreement in the case meant that those two lawyers needed to get a conflicts waiver from all of the joint defense parties. Issue being, was the conflicts waiver from the paying clients enough? And the answer was, in fact, it was not enough, according to the US District Court in Newark, New Jersey. The joint defense agreement had created an implied attorney-client relationship between the lawyers and all other defendants in the action, so conflict waivers should have been sought and obtained from those other defendants as well. As a result, the new law firm was ultimately barred from representing the plaintiffs in that case. I think this is a good reminder to be careful whenever there is a joint defense agreement. Also in litigation generally, that presents a lot of confidentiality, potential privilege issues, so just something to be careful of. And then it also highlights the importance of two relevant rules. 1.09, I think Graham might have just mentioned, governing conflicts of interest involving former clients and prohibiting lawyers from, without prior consent, representing a person in a manner adverse to that former client if the two matters are the same or even just substantially related. And then also rule 1.09B, which imputes those rule 1.09 conflicts to all members of the successor firm.
So the next one is Elizabeth Holmes, who has made a lot of news recently, well, really for like the last decade. And it's interesting here when you talk about joint representation, this creates a very interesting situation because Elizabeth Holmes was so wrapped up in the identity of her company, Theranos, that she was the CEO of, that the two were kind of indistinguishable. And so early in, I think 2013, well, she's been convicted of multiple counts of fraud and conspiracy to commit fraud. That happened earlier this year. But during the trial, she moved to try to claim privilege over 13 emails that were with her elite New York counsel. And she argued that her understanding was that the attorney and his law firm represented her in an individual capacity, not merely as a corporate representative of Theranos. The government successfully argued against that, saying that there was no joint representation and thus the documents were subject only to Theranos privilege. The court applied the graph test and essentially said that there wasn't a clear representation letter here or an engagement letter outlining that the firm represented both Theranos and Elizabeth Holmes. And also that when Elizabeth Holmes was asking for legal advice, she didn't make it clear that she was asking for advice as an individual and not just asking generally about corporate matters of Theranos. The last part of this that she lost, which was kind of across the board, was that she, in these emails that she was claiming individual privilege over, there were multiple Theranos employees, so any privilege that had exist was waived. So these 13 emails were ultimately, the court said that she could not claim privilege over them. And the court explained it like this: to demonstrate, envision a Venn diagram with one circle for company legal matters, another circle for individual legal matters, and a small area of overlap for common interest. In rejecting Holmes' argument, the opinion stated that Holmes admits that there was no engagement letter relating to the law firm's representation of Ms. Holmes and or Theranos. Holmes heavily relies on her belief that the firm jointly represented her and Theranos. However, Holmes' subjective belief is not the standard. The standard is a clear communication that the individual sought legal advice as an individual, not as a representation of the company. And on that, Holmes falls short. There's a little bit of a circuit split on this, and joint representation is a really murky subject. Some circuits will apply a subjective understanding test, but here that was rejected. Both the magistrate and the trial judges rejected Holmes' privilege, and the 13 documents in question were all admissible. And like I said, she was convicted on 4 of the 13 or 11 counts brought against her. Sentencing is happening later this year. The takeaway here, just be very clear in all engagement letters who falls into the scope of representation. And if the intention is to set up a joint representation, make that explicitly clear in the engagement letter. So this is an extremely played out YouTube video that I'm sure everybody is very familiar with. I think when this came out, I got emails and texts from so many people, especially because I practice in Texas, and this just kind of summed up Texas to a lot of non-Texans. So this is the lawyer cat, Rod Ponton. Old news, so we're not really going to talk about it, but amazingly, the same judge in another Zoom hearing had someone with a very similar situation where, although their face appeared, this is, so their face appeared, I'm trying to remember the name, Life Festa or something like that. Face appeared, but they had some audio filter, which it baffles me why this is an option on Zoom. I don't know who this helps. But I guess I have the same question about a cat filter, so I don't really understand it. But apparently, whenever he talked, a chipmunk's voice came out. And I've watched the video. You can find it pretty easily, and it's inaudible. It's not like what he's saying is being filtered into an understandable chipmunk, if such a thing. I mean, it's pure gibberish. But it is pretty funny to hear, similar to the cat video, to hear the judge try to navigate this situation where he can't understand anything. And then, of course, unlike the cat video where the guy can explain that he actually is not a cat, I guess it was apparent based on the image that he was not a chipmunk, but he could not explain that because nobody could understand what he was saying. Also, there's a little bit of question here about if this is genuine, because same judge, pretty much the same situation twice. I don't know. You guys can decide.
I actually had asked Graham earlier if he could do the chipmunk voice for us, but that was a little bit too much.
Yeah,
for
maybe.
Graham.
I think Jordan probably could have done it, but that's where my stand-in stops. So as a final note, there actually are no laws forbidding a cat or chipmunk from practicing law in Texas. A person commits an offense if the person practices law without a license, not cat or chipmunk. Again, the person may not practice in this state unless the person is a member of the state bar. Again, only applies to people.
I was just going to add one other thing there that we were talking about yesterday. We actually had recently in our offices in a major matter that we were kind of hoping that all of these Zoom mishaps would be coming to a close, but unfortunately, a lot of courts are still doing by Zoom or in person. So there was a few things that I did want to add to sort of this funny tidbit as real life things that we're still seeing happen. So the other day, for example, we had a hearing, contested hearing, 5 sides, and one person just could not connect. I mean, they were in their office. At first they were on, no volume. Then there was volume, no video. And we have all sorts of rules for any of you that have been dealing with this about if you have a declarant, a witness that's going to be testifying, then that person, and this is what comes up for our in-house counsel that we're working with, that right now it's really important that you visit with your counsel about if you're supposed to be there in person. Do you have to have a video? Some people don't know that they're going to need to be videoed and then they're in their pajamas. These are things that are still happening all the time, which are, I mean, just I think if we plan better, it won't happen. And so just coordinating on that. And then I actually have heard some of our judges complaining still about people not being mindful about their backgrounds, distractions. Of course, people, the obviously dogs and your kids, you know, you can't keep them out. But one lawyer a couple weeks ago still presenting in front of his home bar. So anyways, these are just things that are, again, kind of things that people are watching. Our judges are not enjoying them and to be mindful of.
And I think on that vein too, we tried a case last year that was all done via Zoom, and most of it took place in our conference rooms. So we had most of it figured out. But when you have witnesses that are going to take or give their testimony at their office, there's a lot of issues that come up with that. And so just practically, like my job was to coordinate with the IT groups inside the office of our client and make sure that the video worked. I mean, you can't over prepare for something like that because there's nothing worse, especially when you're on the record and you're using valuable trial time or deposition time to just make sure that everything's going to work beforehand. And a lot of times it doesn't. So it's better to be prepared.
And our parting blow here, mistakes. It could be that the purpose of your life is only to serve as a warning to others. And with that bleak thought, we open for questions.
So my question is you mentioned repeatedly the ethical rule that says a lawyer may not commit a serious crime. How serious is serious? Just, I'm not asking for myself, I'm asking for someone else.
Yeah.
Definitely not parking violations. Those are okay.
You know, I think that's a really interesting question. There was another news story I saw recently that I don't know if any of you all have seen, but about somebody that was at the protest at the Capitol. They were present at the protest. I mean, I think this is a news story that could get kind of controversial, but what I've read, they didn't actually do anything that was criminal. There was no crime, but they were actually terminated from their job. They didn't lose their license. So, I mean, it didn't violate 8.04, but I think the point there is that we really, as lawyers, apparently really need to be careful about what we're doing in the other contexts of our life. We were actually discussing before this that, I mean, you should still have the ability as a lawyer to participate in a protest. I mean, that's one of our rights, but I think people need to be careful about, you know, how they behave during those situations. And then also we've seen cases where people have posted something on social media. That was a slide we had in a longer presentation we did another time, where somebody posted something on Facebook about a case that they'd won and they were excited about it, but it included some confidential details, and that resulted in an ethical violation and actually a consequence to their license. So there's no hard and fast rule. And if anybody wants to chime in on that, but I think if you got a crime, like an actual crime that you could go to court on, then certainly you have a problem, absent like parking tickets and something that's not really a moral issue.
And I think on that front too, the rest of the statute says that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, or engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So I think it has a lot to do with that kind of notion that lawyers should be in some ways above reproach, especially as it relates to client representation and things like that. So I think honesty and that kind of moral component definitely plays a role in that definition as well.
had a quick question about the joint defense group one. I thought that was interesting because when you form joint defense groups, usually you are relying on some sort of privilege so that you don't have to disclose all the strategy calls that you've made to the other side. And yet the ones that I've been a part of, we're not usually thinking that each of the lawyers representing those other clients are also representing us. And so do you think in that case, it was because they had an exotic clause in the joint defense agreement that sort of led to that type of argument? Or is the sort of joint defense common interest privilege something that then leaks into somehow outside counsel for one client because they're part of a joint defense agreement somehow has obligations towards others that are part of the joint defense group?
Well, I'll go first. I think that that is a really interesting area, and I agree with you. We're a party to these things all the time, and I don't think that the court would reach the same conclusion every time. I think the facts are different. And to your point, I know every single time we're a party to one, we're spending a lot of time making sure that we have that joint defense agreement in place before certain documents are shared. But we are a lot of times having those calls before it's formalized, crystallized, I guess, in a final form. So I think you could have language in there clarifying that one person doesn't represent all of them. That would certainly have those other defendants would have had a bigger obstacle to overcome when they were complaining down the road that they were represented. So we try to build that into our language, but I think it really depends on what your joint defense agreement is. And I think having a written document in place is critical. I see we also have our CLE number up, so that might mean that we're done. But thank you all so much for your time.